Namaskar, dear students. I am Dr. Vibha Sharma, Associate Professor in Government Law College, Ajmer, with the ninth lecture of mine, in which I will cover the aspect of compensation to victim, particularly crime victim, under the subject of victimology. Without going into the nitty-gritties of it all, only the important parts have been covered in this video. Though there are other special compensatory provisions also, such as under the Probation of Offenders Act of 1958, the Motor Vehicles Act of 1988, and the Fatal Accidents Act of 1855, etc. But in this video, we will know about the compensation which is given to the crime victims, as I said in the very beginning. Thereby, the provision contained in the Criminal Procedure Code of 1973 will be covered in brief, as you might have already covered them in detail under your subject of Criminal Procedure Code separately. So let's know about compensation, developments in this regard, and the Indian position, along with its constitutional perspective and the court's view. Before starting with the compensation to the victim, let's have some considerations with us beforehand, which are actually necessary to know and to keep in mind. So one important and basic factor in the administration of justice is the victim's decision as to whether he or she would invoke the judicial process. Correct? There are a number of motives and factors responsible for the wide gap between the actual volume of the crime and the reports made to the police about it, isn't it? Crime reporting to the police would obviously depend to a great extent on the victim's perception regarding efficiency of the police and the likely response from them, isn't it? Now we all know that the police may not be the only inhibiting factor constituting obstacles to the invocation of the criminal law process by the victims. The victim continues to suffer at all stages subsequent to the reporting to the police as well. And these sufferings include financial losses as well, other than the harassment and humiliation and various other kinds of inconveniences, etc., etc., that the victim actually suffers. Right? So let's start with the aspect of compensation to the victims. We know that the word compensation means a thing or financial help given to the victims of crime with a view to make good the loss of property or injury sustained by the victim in person. This would show that the whole purpose of compensation is to make good the loss sustained by the victim or the legal representatives of the deceased in case the victim is dead. So now the compensation to crime victim is not being considered as a punishment to the offender. Rather, it is being considered as an obligation on the part of the society to reimpose faith and confidence on the victim, which has been lost due to the offender's act of delinquency and crime. Right? Though there have been many developments over a period of time as far as the compensation to the crime victim is concerned, we will just go through some of the important developments that have taken place world over. The concept of restitutive justice was sought to be revised in the 19th century by some eminent criminologists like Garofalo and Ferri in Italy and Bentham in England. Though in 1926, Sweden introduced a system in which victims were paid compensation out of the fine imposed on the offender, some concrete progress was made in Europe, US, and some other countries commencing from the early 1960s only. We find that the schemes to pay the victims out of public funds were introduced in Europe, Canada, Australia, and New Zealand. Switzerland actually went a step ahead to the extent of amending its constitution to promote victim compensation programs. So the system of restitutive justice is not confined now to payment out of the fines imposed on offenders, but the state has also accepted responsibility for compensation in varying degrees in some countries. The interest in the victims of crime has been quite rapid in the 1970s and 1980s, during which time many international symposia were held to focus attention on the victims of crime. In 1979, the World Society of Victimology was formed, and the Seventh Congress on Prevention of Crime and Treatment of Offenders in 1985 focused its attention on the problem. In recent years, almost all the countries of Europe and North America have passed legislation to protect the interests of crime victims. We already are aware that in 1985, the declaration was adopted by the United Nations General Assembly, about which I already have shared with all of you in my previous video. As we have seen in the previous slides, that the state compensation programs are very much in place in very many countries now. We come to the position in India. We are aware that Section 357 of the Criminal Procedure Code of 1973 deals with compensation to crime victim. For convenience, I will read out the relevant part only. Whenever under any law in force for the time being, a criminal court imposes a fine or a sentence of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied in defraying expenses properly incurred in the prosecution, in the payment to any person of compensation for any loss or injury caused by the offense, when compensation is, in the opinion of the court, recoverable by such person in a civil court. When any person is convicted of any offense for having caused the death of another person, of having abetted the commission of such an offense, in paying compensation to persons who are, under the Fatal Accidents Act of 1855, entitled to recover damages from the person sentenced for the loss resulting to them from such death. Then we find that subsection 3 of section 357 was added as recommended by the Law Commission in its 41st report, provides when a court imposes a sentence of which fine does not form a part, the court may, when passing judgment, order the accused person to pay, by way of compensation, such amount as may be specified in the order to the person who has suffered any loss or injury by reasons of the act for which the accused person has been sentenced. You can look up for these provisions under the Criminal Procedure Code as such. Then again, we find that by way of Criminal Law Amendment Act in 2013 and 2018, two more provisions have been added and amended. Section 357B, which talks about compensation payable by the state, shall be in addition to the payment of fine to the victim under Section 326A, 376AB, 376D, 376DA, and Section 376DB of the Indian Penal Code of 1860, and Section 357C also adds some of such provisions and provides that certain victims shall be provided first aid or medical treatment free of cost by all hospitals, private or public. Okay. Of course, it is to be noted here that it is not like this, that in earlier times, that is before these legislations came into place, there was no system which actually took care of the victims. Of course, it was very much there. But for our purposes, these legislations are the focus under victimology at the moment. Okay. So after learning about the provisions contained under the Criminal Procedure Code, we now move on to the court's view as to how they have been considering this particular aspect of compensation to the victim. And we find that in 1978 itself, in Sarwan Singh versus State of Punjab, the Supreme Court of India held that in awarding compensation, the court should not first consider what compensation ought to be awarded to the heirs of the deceased and then impose a fine which is higher than the compensation. They said that it is the duty of the court to take into account the nature of the crime, the injuries suffered, the justness of the claim for compensation, the capacity of the accused to pay, and order, of course, under relevant circumstances, in fixing the amount of fine or compensation. The fine, they said, will be paid as compensation to the widow of the deceased. And they further held that in default of payment of fine, the accused will undergo further simple imprisonment for 6 months. So you can very well see that the honorable courts were already considering the aspect of compensation to the victim. Then again, in 1994, in the case of Jacob George versus State of Kerala, the Supreme Court, while discussing the importance of compensation to the victims of crime and holding that Section 357 of the Criminal Procedure Code embodies the said concept of compensation as such, also said that this power shall be exercised by the courts having regard to injury or loss suffered by victims and also paying capacity of the accused. Okay. Of course, in quite a few cases of death caused by rash or negligent act, punishable under Section 304A of the Indian Penal Code, the courts have reduced the period of imprisonment to the one already undergone, but imposed a severe fine in order to provide substantial relief to the dependents of the deceased. We find that in the year 1995, the Supreme Court of India, in the case of State of Punjab versus Ajaib Singh, gave a new dimension to the idea of compensation, where it held that the respondent, who was a police officer, will deposit an amount of rupees 5 lakhs even though he was acquitted by the High Court. So the court generally says that this power shall be exercised by the courts having regard to injury or loss suffered by victims, and also paying capacity of the accused is to be taken into account, as was held in Roy Fernandez versus State of Goa in 2012. But of course, in 2013, the Supreme Court of India in Ankush Shivaji Gaikwad versus State of Maharashtra observed that it is evident that only marginal action is possible under Section 357 of the Criminal Procedure Code to compensate the victims of crime. The Indian courts have taken a strong view in order to award compensation to the victims of crime, and they have said that even the state is bound to compensate the victim where accused cannot pay adequate compensation. And the court held that under Section 357A, the court is empowered to direct the state to compensate the victim even if the accused is acquitted, and also that award of compensation is a mandatory duty of the court, and the court has to apply its mind to the question of award of compensation in each case. Okay? It is also worth noticing that the court said the use of the word may in section 357 does not mean that court need not consider applicability of section 357 in each case. Correct? Now, coming to the constitutional perspective of compensation, we find that the courts have taken the cognizance of the cases where they pay the compensation to the victims, especially where one of the parties are state. They generally take recourse to Article 21 and they award compensation in cases of constitutional torts. Generally, where there is gross violation by the states of the fundamental rights, the Supreme Court has been giving relief in the form of compensation under Article 32 and 226 of the Constitution. Like in the year 1983, the Supreme Court in Rudu Shah versus State of Bihar ruled that the court has the power to award monetary compensation in appropriate case where there has been violation of the constitutional right of the citizens. Now, in the instant case, the Supreme Court ordered the state government of Bihar to pay to the petitioner a sum of rupees 30,000 by way of damages for illegal detention in jail for 14 years, even after his acquittal, due to the negligence of the state authorities. Then again, we find that in 1993, the Supreme Court in Neelabati Behra versus State of Orissa ordered that the state should compensate for the violation of human rights and could not claim protection of doctrine of sovereign immunity. In the instant case, the government was ordered to pay rupees 1.5 lakh to the petitioner for violation of Article 21 of the Constitution, as the young husband of the petitioner died due to torture in police custody. Then again, in 1997, the Supreme Court, while holding the state responsible for the violation of Article 21 because of the fake encounters by the police, in the case of People's Union for Civil Liberties versus Union of India, held that if it is proved that the person has been killed, the state may be directed to pay the compensation to the family of the deceased. In yet another case, holding the state responsible, gave compensation to the victim of rape at Rail Yatri Nivas in the case of Railway Board versus Chandrima Das. In Phulwati versus NCT of Delhi in the year 2000, the Supreme Court again gave compensation to the relatives of the deceased because the death had occurred in police custody. So the courts actually recently have started laying emphasis on shift from retribution to restitution of victims, particularly in view of declaration and amendments in Criminal Procedure Code of 1973. The idea of victim rehabilitation has strengthened. I really hope that by this video, important aspects of compensation to the victim of crime stands clarified to all of you. In my next video, I would be taking up the aspect of compensation and rehabilitation. Considering the sensitivity of the issue, I hope that you will keep all the aspects in your mind whenever you will have an opportunity in your life to deal with such situations and such cases, be it as an advocate or as a judicial person. Well, wishing all the best to all of you. Please take very good care of yourself and do very well in your examinations. All the best from the bottom of my heart. Thank you so much. God bless you all.